May I please,
Yes,
may I please, Your Lordship, beg to mention item number 15, my lord.
yes.
My lord, we have received instruction from the petitioner that not to appear for this matter. Maybe they have engaged new counsel. So kindly name should
You
be
have been instructed not,
item 15. Not to appear for this matter, my lord.
who is not going to appear?
Maybe new counsel has.
No,
been
no,
engaged.
who are you? Who are you?
I'm for SM Mannan, appearing for.
You are YS Manan.
Yes, my lord.
What about Munir? Munir also will not appear.
Yes, my lord.
A Sharma will also not appear. A Saike will also not appear.
Yes.
So what is your name?
Al Islam. I'm
The
appearing
one
for.
whose name is not a she comes and says.
She is on behalf of her senior.
Yes, my lord.
Okay. But who is
prepared the
the
case.
council who is going to appear on behalf of in item 15?
My lord, I don't know.
Let the
Should-
matter be reached.
Shouldn't they go to the registrar or something and inform
No,
them?
let the matter be reached, my lord. Somebody might appear. If
Ah.
nobody appears, amicus curiae will
Okay.
legally consider.
My lord, our name should be strike out from this matter, my lord.
Wait, we'll see. Let the matter. Anyway, you see, it might not reach today. That is the problem. It's item 15 hearing.
I leave it to your lordship, my lord.
I think we'll write it.
And if
statement.
they want
If
to
they
strike
appear,
off,
then we'll modify the order.
if they want to strike off, they have to inform the registry first.
Yes, that's what I'm saying. They should, you have got to approach the registry. Okay, right, Miss
Al Islam.
El Islam. Submits that she has been instructed by her senior, Mr. Y.S. Manan, that Mr. Y.S. Manan, Mr. S. Munir, Mr. A. Sharma, and Miss S. Saikia shall not be appearing for the appellant, as they have come to learn that the appellant has engaged some other lawyer to represent him. Ms. B. Buyan, additional PP appears for the state. On considering the submission made by Ms. S. Islam,
Al Islam. my lord.
El Islam, the counsel for the appellants are directed to inform the
Registry.
which registry? Which registry?
Registry judicial or
The concerned registry, to inform the registry. To inform the registry with regard to the submission made by her for striking out their names as counsel for the appellant, as counsels for the appellant. List the matter after 2 weeks.
Thank you.
Your Lordship, I'd like to mention, with the consent of other side, I would like to mention item number 16. Mr. N. Deka, who is the amicus in this case, is out of station. So may the matter be adjourned for today and kindly be listed after.
What to do?
He informed me last night.
Yeah, as per the notification issued by the court, you are supposed to give in writing.
Your Lordship, inadvertently, it was not submitted, but consent was been taken.
Maybe, but then what about our consent? What do you think we do?
Mr. N. Deka is out of station, I think.
Right. Just see, item 16 was adjournment taken last time also. And we'll change the council. No. Right, on the prayer for adjournment made on behalf of Mr. N. Deka, learned amicus curiae, who is out of station, and which is not objected to by Ms. S. Jahan, addition PP. list the matter after it. To stop. In this, right? In this case, comma. The witness, the PW8, comma, who is the son, has given his evidence to the effect that his father had told him that he had killed his mother with a bat.
It's an extrajudicial confession.
The son has said, father told me, killed his mother with.
Much.
Order has been already complied with.
Huh?
Order has been already complied with.
Item one,
One minute.
complied with or not?
Yes, my lord.
What order? The money,
Yes, my lord.
5 lakhs,
That will receive, my lord. 20 lakhs, my lord.
20 lakhs. You should pay more in fact.
You know, my lord. 14 lakhs, 50,000 already received after retirement.
Okay, so this contempt petition can be closed.
Yes, my lord.
Mr.
Yes, I tell the.
Learned counsel for the petitioner submits that the contempt petition can be closed as the permanent alimony to be paid by the respondent has been paid to the petitioner. So, Mr.
Age das.
H dash appearing for the respondent also submits that the contempt petition can be closed as the permanent alimony has been paid in full. Full stop. In view of the submission made by the counsel for the party, the contempt petition stands closed.
I will tell them.
What? There's IA. IA also will be closed according
I
to,
part, it was already.
Huh?
Yes, my.
but nothing was mentioned, no?
Yes.
Right, in view of the order passed in the contempt petition, the IA is also closed accordingly.
I will.
Actually, it has been disposed of, but it's not stated disposed of, that's why.
Yes, my lord. Contempt.
Anyway, right.
Two to five are the amicus,
But with, yeah,
jail appeals,
right,
2-5.
this is the jail appeal filed against the judgment dated 20/02/23, passed by the Court of the Additional Sessions Judge bracket FTC, Barpeta in Sessions case number 7 of 2022, by which the appellant has been convicted under section 376/511 IPC and section 325 IPC. Admit the appeal, call for the LCR. Issue notice. Is it required?
376, but not preferred. POXO only.
All right, okay, right. Ms. S. Jahan appears for the state. So, this is the matter. Do we appoint or what?
Can appoint the lawyer
Who
also.
do we appoint?
Registry can also. Yes, sir. Yes, sir. So others are not.
You give, huh?
Yes. Victim is 52 years old.
52 years old.
52, victim is 52. Anything is possible.
I don't know what to do. People are so depraved.
Accused is 27 years.
Oh. Yeah, what to do? People are so depraved. So what to do?
Registry is rejected.
Right.
Three.
Huh? Yeah. Out of four. Same.
Bipika. Meghalaya.
Then after you say judgment dated. (17/5/2023). Acha, by the court of, by the Sessions Judge Dibrugarh. In Sessions case number 258 of 2014. Convicted under
Three.
302. Then who is the, am I-
D. Debashri Saikia is there.
please, I can-
D. Debashri Saikia.
Single bench.
No, she is there before DB also, I think.
Only for single bench.
Oh, acha, acha. D.
Okay,
Saikia. Okay, then,
you don't have a list.
we had
Okay, okay, just say this, who?
Meghali Burman is there. She keeps doing.
Okay, M. Burman. And next. Judgment dated 18/5/23 passed by the additional session judge bracket FTC. Comes special court POXO Dibrugarh in POXO case number 19/2020. Admit the appeal, call for the LCR, issue notice, returnable in 4 weeks. This is the hand. Additional PP accept notice on behalf of the state. Notice should be served upon the informant,
Boxer
victim,
matter.
upon the victim. Victim,
Through the
through the-
OC.
through the OC of the concerned police station. Who takes steps in this regard, the special, the additional PP,
Actually, we should.
in
This
the,
is what the
in
judgment
with
says.
regard to the above, the additional PP shall
Take steps.
take steps for compliance with the above directive. Then, that conviction made under section 6, box 12. The reason I'm putting all this is so that the registry doesn't have to, turn the pages. Yeah, they have to,
Easier for them.
the easier.
Amicus-
they have to prove it. Amicus,
Amicus Arunaksha Dhar is there. Bornali Chaudhary is there.
oh, you tell.
Aid her.
Aid her.
Ma'am, please. Lordship India and the.
Okay, right, right, Mr.
FO.
F. Huck, learned counsel for the appellant. Who submits that the judgment dated
31/5.
31/5/2023 passed by the court of the additional session judge number 3 Nagaon. In sessions bracket T-1 bracket close case number 47 bracket N of 2015, by which the appellant has been convicted under section 302/34 IPC. Should be set aside. Mrs. Jahan accept notice on behalf of the state. This is the matter for it.
And Lordship I is there.
In the IA, right, Mrs. Jahan, then additional PP is granted 4 weeks time.
Yeah.
To file WO. This is the matter before.
Ablash.
Okay, heard Miss
Arvigam.
R. Begum,
Arvigam.
learned counsel for the appellant, who submits that the judgment dated 9/6/23 passed by the court of the session judge Siva Sagar in sessions case number 99 bracket S-S of 2018 by which the appellant has been convicted under section 302. No, 302/34 IPC. Should be set aside. Same thing, huh?
I also say.
I same. Okay, I heard Mr. P. Learned counsel for the appellant who submits that the judgment dated,
28.
huh?
28/6/22.
What about this 22/6? What is this? Why two dates? Why two numbers?
The date of sentence.
Sentence
of
is
sentence,
28,
yes.
conviction is 22. The judgment dated 22/6/23. And sentence order dated 28/6/23. Passed by the court of the additional section judge Gilasi Para. In section case number 168 of 2012. By which the appellant has been convicted. And by which the appellants Sahed Ali, Habibar Rahman and Zamal Ali. This is in page 78, huh? Para 152. That name that. Have been convicted
Page number one.
under section 147/148/302/201 IPC and sentenced accordingly. The above three appellants are no, are a part of a group of 10 appellants.
Yes, sir.
Who have been convicted on the same set of charges. Miss El Jahar, access notice on behalf of the state. This is the matter of the 4 weeks. huh?
Just along with that.
Huh?
I
I-
again same on.
I, right, Miss El Jahar, you granted 4 weeks time to file written application.
And the criminal appeal, list along with criminal appeal number 254/23 lot.
List this matter in the main appeal,
Okay,
list the matter along with criminal appeal number
254/23 lot.
254/20. So, yes, actually records might already have been called.
No,
for.
must have been called in that matter.
Already, so we won't say call for the record, don't say call for the record.
Yes, sir. Made visual lordship. Lordship, we have taken a step upon the resolution of two lordship. So as per office note dated 19/7/23. Service.
There is no AD, what to do?
Boxo. 302 matter.
Yes, okay, right. As per office note, LCR has arrived. However, there is no return of AD card or unserved notice from the respondent number 2. As this matter pertains to section 302/34 IPC, registry to make the paper book and give copies of the same to the parties. This is a matter after 4 weeks.
Nine, there is a delay.
140, any objection? 147 days,
No,
madam.
Lordship, but no, the council is also not here, Miss N Hassan. Perhaps Mr. N Hassan.
I don't know.
I know one Nurul Hassan, but this is MS. Because I have no objection, Lordship can condone the
We'll
delay.
allow this, right. This is an application for condoning the delay of 147 days in filing the appeal against the order dated, against the judgment dated 1/12/23 passed by the Special Judge Baksa in special bracket P, case number 81/2018, by which the applicant slash appellant has been convicted under section 4 of the POCSO Act. Ms. S. Jahan, additional PP submits that she has got no objection to the delay being condoned. Next, on considering the grounds for the delay in filing the appeal and keeping in view the submission made by the learned additional PP, the delay of 147 days is condoned. Registry to register the appeal and list the same after a week. I is accordingly disposed.
The victim cannot have any say in the matter as far as condonation is concerned, I think, because Supreme
Uh-huh.
Court said bail only.
Only on the main.
With the lordship, I for condonation of delay in 176 days.
Any objection, madam? Right, Miss P. Bora, learned counsel for the applicant submits that there's a delay of 176 days in filing the appeal against the judgment dated 9/6/22 passed by the Session Judge Golaghat in Sessions Case number 2/2019,
And sentence within manner 60.
by which the appellant has been convicted under section 302 IPC. Miss S. Jahan submits that she has got no objection to the delay being condoned. Same, huh? Same thing.
Wait, please, my lord. My lord, matter pertains to enhancement of the maintenance, lord. My lord, on the last date, my lord had suggested us for a monthly maintenance.
Huh? Louder, louder.
On the last date, my lord had had suggested us for a particular amount regarding rupees 20,000 as monthly maintenance. For the wife, my lord, I am the wife in this case. My lord, in this regard, my lord, I have placed two authorities passed by the Honorable Apex Court. If my lord would kindly peruse the same.
Where are the authorities?
My lord,
If
I have,
I'm allowed to say, madam, there is an application for madam, modification of this order, madam, of enhancement, because madam, on the ground that
Since those are done in June. You see, they've suddenly done it, woken up because it's being listed.
Yes.
Because we fixed a certain date. Imagine if we did fix a date, it would have been stuck there. We'll have to wait for some time. Right.
And there is one more issue, what my learned friend is saying.
In the present case, my lord, there were 13 accused persons, my lord. 5 were acquitted. Notice should go to them as well, my lord.
Because notices were issued to
Notice
the
has to be
acquitted
got to them, to the
respondents.
acquitted person.
In the cross case, notice has been issued, my lord.
Okay,
In the present case, also 5 were acquitted, my lord.
okay, right. Heard Mr. B.K. Mahajan, learned counsel for the appellant in criminal appeal number 82/2018. And Mr.
VH on the reader.
V.A. Chowdhury. For the appellants in criminal appeal number 85/2018. Ms. S. Jahan, additional PP appears for the state. In pursuant to the order dated 15/6/2023. Notice has been issued to the accused persons of Sessions Case number 347/2015 on 20/07/2023. Await service report. Then you write. The above being said, comma. Out of the 13 accused persons, correct?
13, my lord.
In Sessions Case number
131.
131/2014. How many had been acquitted?
5, my lord, page 203.
5 had been acquitted.
1.
203.
Page 2, the paper book. First paragraph.
First off, para 60 you mean?
Paragraph 57 it is, my lord. Page 203. my lord.
Oh, yeah. comma, full stop. They are Alim Buyan, alias Ali Buyan, comma, Shahjahan Buyan, comma, Nurul Buyan, Anisur Rahman, and Halim Buyan. Page 203, first paragraph. We are of the view that notice has to also be issued to the above 5 persons. You take steps. Full stop. No, you take step. Appellant shall take steps for service of notice upon the above 5 persons.
In respect of others, I think registry.
That is already done. So that, but
They were not actually parties in the proceedings.
We
So-
will not be able to take steps.
okay. Then the registry to take steps for service of notice upon the above 5 persons. Take steps for service of notice upon the above 5 persons. The same should be done within a week. Full stop. List the matter. Give a date after 6 weeks.
Obliged. Highly obliged.
2 minutes.
2 minutes.
কি অবশ্যই পেশেন্ট দেখা
Gratefully, Lordship. Lordship, last order may kindly be perused passed by this honorable court, Lordship.
Who is the appellant? Appellant,
Appellant was there, Lordship.
Ah.
When the matter was come up, he's gone out of the court.
he was here.
He was here.
Then we'll wait for some time. Otherwise you call it. We cannot pass an order. Now, what has happened now? Has he paid you the money?
No, Lordship.
No, nothing.
He just informed me inside the courtroom that he has deposited only 3,000 as per the appellant's counsel.
Wait for some time.
We'll send him to prison.
My landed friend is appearing.
Appellant's appeal.
May I please your lordship, I beg to mention on behalf of Mr. K. Agarwal. He is out of station today due to some urgent work.
He called me up yesterday. I too was not very well, so I also couldn't prepare. I had severe headache yesterday also.
He's gone out of station. Couldn't he have informed everyone earlier that he was going to go out of station?
He was not,
Huh?
actually, he was not,
He
but
decided
suddenly he
it's
had to
urgent.
leave due to some urgent work.
Last
Otherwise, he's
night-
ready with the matter, but due to some urgent work, he had to leave.
Around 9 o'clock and all, he called me up
No.
last night.
If your lordship, may fix the date,
Right.
third.
On the prayer for adjournment made on behalf of Mr. K. Agarwal, the learned amicus curiae, who apparently had to leave the city due to some emergency. Come on. List the matter after 2 weeks.
Yeah, please, Your Lordship. This matter was taken up on Friday last night, wherein I had submitted that none of the documents, not even
Huh?
a single document was submitted as an exhibit. Madam. Neither the IO was examined.
This item,
Item 21, madam.
supplement. Yes, what about this case?
At least two decisions, my lord, she was to respond to that.
We have heard this matter. No.
On the outset, I had given that
Yes.
point that none of the documents have been exhibited in this case, neither the FIR, charge sheet, nothing. It was listed last
Okay,
Friday,
okay. No documents exhibited,
neither the IO was examined.
examined.
And I had given two decisions that this is a legal infirmity and should be remanded back so that those exhibits can be taken on record.
Where is the? Okay, in this Shivnath Prasad, where is the relevant portion?
Paragraph 13, my lord, 13, 20, 22, and 24.
No, Shivnath Prasad different.
Shivnath Prasad is paragraph 5. Paragraph 5 and 7.
Okay, in this case, you have been convicted
I was convicted.
on
There are
what
two
ground?
child witnesses,
302.
you know,
Huh?
30.
two child witnesses are there.
Child witness.
Yes.
Yes, anything, madam?
Lordship, I have got judgments on both the sides. If the IO is not examined, sometimes it's settled to the prosecution. And certain judgments I have found wherein if the prosecution could stand on its own legs, then non-examination of IO is not fatal. It should cause prejudice to the accused, Your Lordship.
And then what about the non-exhibits of document? Non-exhibiting of document?
The irregularity in the prosecution case, Your Lordship.
How do you prove that? How do you prove that?
Contents of the document has to be proved.
How do you prove that the person died of some injury?
Lordship, it was post-mortem report, it was cited as exhibit 1.
Yes, right.
It just cited, yes.
It was not exhibited because in the judgment itself it says
I don't know.
the FIR has not been exhibited.
You see, we don't know, we're not sure. So it depends upon how you place the materials before us.
Yes,
But you see, for a criminal case to start, to be initiated, you need the FIR.
yes.
Okay, it is there, no doubt. Was it ever, was in the cross-examination? Was there anything stated with regard to the?
IO has not been examined. And in the judgment, learned court below has observed due to, in spite of his best endeavor, he could not, Lordship. he could
Secure the
not,
presence of the
secure the presence of IO. It's observed in the judgment.
No, IO presence might
Not
not be
required.
necessary.
Anybody from the police station could have come. He could have identified.
IO presence might not be necessary. But at least the FIR registration, maybe the medical report. Won't it be necessary? I don't know. You tell me.
No, Lordship, so may I cite
Yes.
those judgments? First, my lord, 2004 7 SCC.
Just a minute. How many judgments are there?
There are more than
More than?
1, 2, 3, 4, 5, 6, 7, 8. Last one is Jehra Habibullah Sheikh for remanding the matter back.
Eight or 9 or 10, how many? Quite a bit.
Lordship, I understand the wastage of paper, your Lordship.
No. it's okay. Yes, number one is,
2004
yeah,
7 SCC 487.
487.
Yes.
Para?
State of Karnataka versus Bhaskar Kushal Swayanto. Para 6 and 10.
To what effect?
Lordship, may I read it once?
Yes. Yes,
In the-
tell us that
yes.
you were forbidden.
They have brought.
You were one each.
Para 5, 6 and
Para 5, 6 and 10.
5, 6 and 10.
Why you giving us 1996? We want 2004.
2004 7 SCC. 487.
Yes.
Para 5. The counsel for the state submitted that the acquittal of the accused is not sustainable in law as the accused had not suffered any prejudice because of the non-examination of the investigating officer and the constable who recorded the FI statement. In the instant case, the session
FI
judge.
statement, what is FI statement?
Oh, shit. Injury. Dental injury. FI statement to police.
First information.
Maybe first information and
First information.
statement.
Yes, then.
So, Lordship, not yes. In an instant case, the session judge issued summons to these two witnesses, but these police officers did not turn up for giving evidence. And the session judge closed the prosecution case as one of the accused had been in the prison as an under trial for a fairly long period. The counsel for respondents 1 to 4, though contended that they were seriously prejudiced by the non-examination of the investigating officer, this plea could not be substantiated by cogent facts and circumstances. It is true that as a part of fair trial, the investigating officer should be examined in the trial cases, especially when against the accused. If any of the prosecution witnesses give any evidence contrary to the previous statement recorded under section 161 CRPC, or if there is any omission of certain material particulars, the previous statement of these witnesses could be proved only by examining the investigating officer who must have recorded the statement of these witnesses under section 161 CRPC. In the present case, no such serious contradiction is pointed out in respect of evidence of the important eyewitnesses, PW1, 2, and PW10. So also the non-examination of the head constable who recorded FI statement is not of serious consequence, as PW1 was examined to prove the fact that she had given a statement before the police. The learned single judge was not justified in reversing the order of session court by holding that the non-examination of the investigating officer and the constable who recorded the FI statement had caused prejudice to the accused. And para 10, your lordship. There is very strong and convincing evidence to prove that these respondents, along with others, had attacked deceased Prakash, PW1 and PW2. The session judge had given valid reasons for finding these respondents guilty. The single judge was not justified in reversing the conviction and sentenced solely on the ground that the investigating officer was not examined by the prosecution. As the respondents were not prejudiced by the non-examination of the investigating officer and also the constable who recorded the FI statement, the finding of the learned single judge is erroneous. Therefore, we set aside this second. This is the judgment.
Para 11 or?
Para 11. In Bihari Prasad versus State of Bihar, I have brought the judgment, my lord. This court held that non-examination of the investigating officer is not fatal to the prosecution case, especially when no prejudice was likely to be suffered by the accused. In Bahadur Naik versus State of Bihar, this court held that when no material contradictions have been brought out, the non-examination of the investigating officer as a witness for the prosecution was of no consequence, and under such circumstances, no prejudice had been caused to the accused by such non-examination. So this is the one which goes against them. Then Bihari Prasad judgment 96 to SC.
No, now we don't need it here.
Lordship.
Why do we go through that?
Lordship, your lordship may skip that. I brought that. I'll give it.
There is a waste of time of it. No, same thing.
Then,
Okay, that aspect though is clear. With regard to IO, it's quite clear.
yes,
Now with regard to.
non-exhibiting. documents.
Non-exhibiting document.
Lordship.
But give us some judgments on that.
Non-exhibiting part I could not bring, but when the officer is not there, lordship, the prosecution could have your lordship because the this one PM report was before him.
The report was before whom?
It was there, it was exhibited, but it was not like contents was not proof, my lord.
PM, the medical report was proof.
Yes, PM report, exhibit 1, page 42 to 45. Yeah, my lord, that's what
Huh?
contents were not proved.
Medical officer was examined,
But it's
but
not
he did not exhibit the PM report,
The document not exhibited.
not exhibited.
So what happens in that event?
So the trial judge, how can the trial judge have the satisfaction?
Because doctor was examined. He stated so. He stated so. Yes, sir. Because it cannot be. He examined the But regarding on examination of market, there is some contradiction.
Okay, one thing in the evidence, is there any contradictions?
So your lordship has to go through the evidence first, my lord.
Yes.
If your lordship finds this serious prejudice has been caused.
No,
to the
we'll have
accused
to
person,
see.
Whether from the mouth of the witnesses. It was, if whether they were contradicted, they could demolish the
Whether they were
person.
contradicted? Huh? Which one? Which witness?
PW1.
PW1.
PW1, man. In our examination in chief, she says that he was being heard, he was being beaten.
Huh?
I had seen
Yeah,
that.
where?
Uh,
Maybe
Page,
it's not a fair friend, I have not stated.
sorry, PW1,
matter.
is a hearsay matter, not PW1 matter, PW2 matter,
PW2.
PW2.
Ah.
In the second line, she says, I had invited my elder brother Hopna Hambro to my residence. We had our dinner by 11 PM and we had gone for sleep. At the time, the accused came to our residence and started shouting regarding the presence of Hopna Hambro in my house. And I told the accused that Hopna is my elder brother, but he would not listen. The accused dragged Hopna of my residence and took him to the courtyard. The accused was wearing sports boot and he started beating Hopna Hambro with his sports boot. I ran to call the villagers. Whereas in the cross-examination, she says, Marot, when the accused dragged Hopna out of my residence, I ran away immediately to call the villagers. She could not have seen that.
This is not a contradiction.
There's not a contradiction.
This is not a contradiction, that is admitted.
Evidence relating that he had seen.
Huh?
Our evidence that she had seen, she was the eyewitness of her brother being beaten. Close away matter.
That is.
No, there are two parts, my lord. Yes, there are two parts. He did not say, he did not say.
Yes,
When
he-
the accused
you
dragged Hopna, that time he
only
went
asked
away.
him whether he saw him being dragged out and him running away, that's all. Where's the contradiction?
Contradiction will be from the previous document, previous statement being made.
Where is that, where is the 161 statement?
161 statement not recent. Not exhibited.
Where is the question of exhibition of 161? Where is the question of 161 statement being exhibited? No, anyway, how does it matter?
No, whether it's a
164 statement has been raised matter, page 57.
But you have not questioned him with 164 statement. Then,
The admission, I have not stated before the court, that is admission. No contradiction. It is not a factor.
At the I have been there, I could have asked that question.
Huh?
Him to contradict.
What?
I could have asked the IO about the 164 statement to contradict.
but you have to first contradict the witness. Only after you contradict the witness can you confirm it with the IO.
No,
You cannot go
not there.
directly to the IO. That
it's
doesn't
not-
help
it's
you.
not there. It's not. there.
He has stated before the IO. লক্ষণ মেয়াৰী মোৰ দাদাহঁতে আমাৰ ঘৰত ফুৰিবলৈ আহিছে বুলি মই কওঁ যদিও ধেনাই জবৰদস্তি দাদাৰ ঘৰৰ পৰা টানি লৈ যায় ধেনা বলো the accused person dragged the victim ঘৰৰ ওচৰতে মাৰপিট আৰম্ভ কৰে আৰু ভৰিত পিন্ধি থকা জোতাৰে বুকু পেটত so attack with the help of like he was wearing boots like
So there is no contradiction. Huh?
He said that injury condition with heavy bleeding from his hand and cheek. Hand and cheek. Here that is head and cheek. Maybe writing this verse a very big type. So it is written this way. And where is hand and this is an original. It's a Xerox copy.
Go to PW4.
PW4. Champrai Mumbai
That is the
is a neighbor, my lord.
Yes, you can start. So basically, there's no documents exhibited. There is no eyewitness, there is no, IO has not been examined. But there are two eyewitnesses.
There are child witnesses also. Two,
How
5
many
and 6.
Who are the eyewitnesses?
5 and 6, lordship, their daughters,
Eyewitnesses PW
5 and
Five.
6.
5 and
And
6.
six.
And what about 2? 2 is eyewitness or not?
2, yes, 2 is eyewitness.
Then PW2 is also eyewitness.
Yes,
2, 5 and 6.
2, 5 and 6. 5 and
So
6 are
3
the,
eyewitnesses.
PW 1 and 2 are the sisters of the victim.
PW
1 and 2
oh,
are the
lordship, but
sisters.
she says, my lord, PW 5. She's an eyewitness to the occurrence. Her competence had been tested. I had seen the occurrence with my own, she's the eyewitness, my lord. I had seen the occurrence with my own eyes.
PW 5.
Yes.
5 and 6.
The deceased Hopna was struck on face by the accused. There is a small road near our residence and incident occurred there.
Yes.
6 is also consistent. She has also stated.
2, 5 and 6.
Yes.
So the fact is, the evidence is quite clear, it appears. Now, the only issue is with regard to the law. I also we are quite, it's quite clear, unless prejudice is caused. Now, there is nothing to contradict because 161 and thing is the same, 161 and the evidence is the same. Now, with regard to whether the failure of the prosecution to exhibit the document, any document, would that vitiate the trial? So can we have some law on that aspect? I think that's the only thing issue.
Yes, yes.
Now the decision that I had placed state of Mizoram.
That is nothing, that doesn't say anything. What it doesn't say the law, just says that.
Says, my lord, that it's a major legal informative. Paragraph 30.
That is like saying it's not proper. Where does it say? Para?
13 is the submission, major legal
That
informative.
is the submission, who's
My
worried
lord,
about
then in
the finding, where's the finding?
finding, my lord, in page, paragraph 24, my lord. In view of our analysis and observations, we are of the considered view that the present criminal reference under so and so is not liable to be affirmed. Accordingly, the impugned judgment and order dated passed by the district judge so and so under section 302, 384, 34 IPC, read with so and so, is hereby set aside and the case is remanded back to the learned district judge magistrate so and so for adjudicating the same afresh from the stage of 313 CRPC onwards, taking into consideration the statements of the accused persons, thereby offering the accused person to explain their part. All the documents including FIR, charge sheet, post-mortem report, seizure list, inquest report, etc., which are relevant and necessary for the prosecution case are to be exhibited and considered. Accordingly, so and so is disposed of.
See, the problem is, in a case where there is an eyewitness to the crime, motive is not important. And absence of weapon also is not fatal. Now, what more do you want? Can a prosecution case fail just because documents are not submitted when there are witnesses who say, yes, we have seen it?
Yes. And seizure of booths were also
Seizure
seized.
list is not produced, the seized items are not produced before the court.
But you are not disproving, you have not countered that. Have you said that
I could
this,
have
this,
countered,
this,
had there been shown
Huh?
to the witnesses, I could have countered those. Had those been shown to the witnesses, they could have said, yes, these are the proof. I could have countered them. I didn't get that opportunity.
May I refer one more judgment, VK Mishra judgment, your lordship.
Yes.
2015 9 SCC,
yes,
588,
VK Mishra,
yes.
that 106.
No,
No, that
The contradiction.
contradiction, yes. 145.
2015 9 SCC, 588.
Yes,
There are 15 onwards, your lordship.
yes,
Section 162 CRPC bars use of statement of witnesses recorded by the police except for the limited purpose of contradiction of such witnesses as indicated there. The statement made by a witness before the police under section 161(1) of CRPC can be used only for the purpose of contradicting such witnesses on what he has stated at the trial as laid down in the proviso to section 161(1) Code of Criminal Procedure. The statement under 161 CRPC recorded during the investigation are not substantive pieces of evidence, but can be used primarily for the limited purpose of contradicting such witness when accused under section 145 Evidence Act. The contradiction of such witness also by the prosecution, but with the leave of the court and a re-examination of
no, no,
witnesses
we're not on
necessary.
this.
Then your
161.
lordship, then para 18. Under section 145 of the Evidence Act, when it is intended to contradict the witness by his previous statement reduced into writing.
No, no, we're not on
Attention,
that.
and para 19, my lord, the straight way, my lord. In the case in and PW1 was not confronted with his statement recorded by the police under section 161 CRPC to prove the contradiction, nor his statement marked for the purpose of contradiction was read out to the investigating officer. When neither PW1 nor the investigating officer were confronted with a statement and questioned about it, PW1 statement recorded as
No,
well.
no, we're not on that.
So when lordship that in IO was not available,
No,
lordship.
no,
there's
we have
yes,
gone past that stage.
My lord,
We have gone
my
past the IO.
my lord.
We are on the issue of non-exhibiting
The
documents. So what does that entail? Well, what is the
Lordship, but
consequence?
evidence of the eyewitness is sufficient. I mean to say, your lordship,
I don't
because
know.
they were lordship, three eyewitnesses, not even one.
With the facts, I think we are quite clear. The eyewitness is there. No doubt about it. And then IO, Supreme Court has said that unless prejudice is caused to the appellant or the accused, that is not fatal to the prosecution. Now, the only issue remaining is when no documents are exhibited, what is the consequence? That's all. Yes, madam, can you help us?
There are few judgments non-exhibiting definitely fatal. Like in case of.
Yes, so please help us.
There are, I didn't bring that
Oh,
diary
diary.
today.
Oh, diary. I
Otherwise,
think
I.
we have got to confiscate that diaries.
Because I remember in one Guwahati High Court judgment, it is said that in certain cases, even non-exhibiting documents can be taken into account. But that is not in respect of criminal case. That was in case of civil. But otherwise, like sanction orders were not exhibited, prosecution sanction orders and all. One arms act case I found.
Sorry, stay senior. Can enlighten us.
Here, what is not exhibited? It depends on the facts rather. What is not exhibited here?
All, from FIR onwards, nothing.
FIR not exhibited, PM report not exhibited, civil is not exhibited.
That will be.
Yes, can you enlighten us?
Yes, Lord, I don't have readily available any decision. Now, the question is the medical report, for instance.
Yes,
Now, had the document came, it would have belied the eyewitnesses of content of the document. If it is medical evidence does not support the eyewitnesses, then the case it's gone. That's where it becomes relevant. And non-examination, you have absolutely of the presumption. Now, the presumption is if there is a document available and that is withheld, the presumption is that had you produced it, it would have gone against it. That is the legal.
it could have gone against. Can we have some citations?
Lordship, yes, I'll try to. I went into the aspect of non-examiner IO only, but I could not find any judgment, but I think I have one Lordship. Once your Lordship had taken up, not before this court, where while your Lordship is in court number 5, might not. Taken up one item, the same issue. now. Hmm? Mhm.
Document take it up on Wednesday, madam. In the meantime, we'll search. We'll get some.
Right. Or we can keep it savvy and in the meantime, you can give us.
Yes,
a
madam,
judgment.
yeah, that can be
That
done.
also can be done. So the only two aspects of the matter. It appears from your submissions, either we uphold the judgment or we remand it. Due to non-exhibition of the
Documents.
I mean, what document was exhibited?
Nothing.
Zero.
Zero.
Lordship.
Nil. Judgment rights nil.
In FIR, he put his something restriction. I was not examined.
Nothing.
Informant state is that. File for not. That which is some. Yes, but I was not examined. So that was not.
Yeah, right.
Lordship, regarding remanding the matter, Jahira Habibullah Sheikh,
Yes.
2004 4 SCC,
2004,
4 SCC, 158. Para 43, 44, 45, 46, 68 and 74.
okay, right. Heard Mr. B. Prasad, learned amicus curiae. And Ms. B. Buyan, learned additional people. This appeal has been filed against the judgment dated 25/3/2019, passed by the Court of the Additional Sessions Judge, bracket FTC, bracket close, comma, Kokraja, in Sessions Case number 179/2018, comma, by which the appellant has been convicted under section 302 IPC and sentenced to undergo
Page 40. Rigorous imprisonment for life.
rigorous imprisonment for life with a fine of rupees 10,000, comma, in default to suffer imprisonment for 1 year. The prosecution case in brief is that an FIR dated 3/5/2000, no, dated 2/5/2018 was submitted by the informant PW one, comma, to the effect that when her elder brother Hopna Hembram, HOPNA, HEMBRAM, Hembram, came to visit her in her house on no. Not came to, you say went to visit. Went to visit their relative Srimati Malo, MALHO, Mardi, MARDI, on 29/4/2018, comma, the appellant out from Srimati Malho Mardi's house at around 11 PM/12 midnight. He thereafter assaulted. The appellant thereafter assaulted her elder brother and stomped on his chest with his boots. Full stop. He also kicked his brother's head, as a result of which his brother died at 5 AM on 1/5/2008. In person to the FIR, Kokrajar PS case number 192/18 under section 448/325/302 IPC was registered. Next paragraph. After investigation of the case was completed, comma, the IO submitted his charge sheet, comma, on having found a prima facie case against the appellant under section 302. Is it? That sheet was under 302 only?
Under 302, page
Under 30, page
47.
Huh?
Page 47, ma'am. Reverently prayed to start trial against the accused under section 302 IPC.
under section 302 IPC. Charge was thereafter framed by the learned trial court against the appellant under section 302 IPC, comma, to which the appellant denied the charge and claimed trial. Full stop. During the trial proceedings, comma, 7 prosecution witnesses were examined by the learned trial. Full stop. Thereafter, the appellant was examined under section 313 CRPC, wherein he took the stand that he did not beat up the deceased or cause did not beat up the deceased, and he was not involved in the death of the deceased. The learned trial court, on considering the evidence adduced came to a finding that the evidence of PW1 and PW2 established beyond all reasonable doubt that the death of the deceased had occurred due to the appellant mercilessly stomping on the chest and face of the deceased with a spiked boot. SPIKD boot. Full stop. Consequently, the appellant was convicted under section 30 and sentenced accordingly. Full stop. Next paragraph. The learned amicus curiae submits that the impugned judgment has to be set aside as no document was exhibited during trial. No document was exhibited by the prosecution during trial. Further, the IO of the case was not examined. Comma. Thereby denying an opportunity to the appellant to contradict the evidence given by the prosecution witnesses. The learned amicus curiae thus prays that the matter should be remanded back to the learned trial court for a de novo trial. No, not for de novo, for the purpose of exhibiting the documents with the concerned witnesses and for examining the IO. Next page. The learned additional PP, comma, on the other hand, comma, submits that there is nothing in the cross-examination of the prosecution witnesses to show that the witnesses were sought to be contradicted in relation to the statements made by them under section 161 CRPC. The additional PP also submits that the appellant has not been able to show that the non-examination of the investigating officer as a witness had caused any prejudice to the appellant. She also submits that in the case of Bihari Prasad, Behari Prasad versus State of Bihar. Reported in 1996 to SCC 317, the Supreme Court has held that non-examination of the investigating officer was not fatal to the prosecution case, especially when no prejudice was likely to be suffered by the accused. The additional PP also submits that the Supreme Court, in the case of State of Karnataka versus Bhaskar, Kushali, Kotharkar and others, 2004, S7 SEC 487 had held that the learned single judge of the High Court was not justified in reversing the order of the Sessions Court, by holding that the non-examination of the investigating officer and the constable who recorded the first information statement had caused prejudice to the accused. Inasmuch as the sessions judge had given valid reasons for finding the respondents guilty. The learned counsel for the appellant thus submits that the prosecution case just submits that there is no requirement of remanding the matter to the learned trial court, as don't say that. Just cut that. The learned additional PP submits that as there were eyewitnesses to the crime in question, on the basis of which the appellant has been found guilty of having committed murder, there was no requirement of remanding the matter to the learned trial. She also, so what do we say with regard to exhibiting documents? As I write, she, with regard to non-exhibiting of documents by the prosecution before the learned trial court, the learned additional PP submits dash, I just put dash.
Yes. That will depend upon if I get some citation.
Full stop. Next para. Acha, one thing at the petitioners council, the appellants council, you just carry on, you just say. The appellants council has submits that all documents, including FIR, charge sheet, post-mortem examination report, Caesar list, inquest report, etc., are relevant and necessary documents which the prosecution has to exhibit during trial. In support of the above submission, the learned amicus curiae has relied upon the division bench judgment of this court in the case of State of Mizoram versus Abdul Jalil and others, reported in 2008 1 GLT 610. The other one is not relevant.
For the line that the prosecution version has to be established, and those are established by the documents, madam. The postmortem report, how the death has been occurred,
No, the other judgment, how is it relevant? The
the last
Supreme Court
paragraph
has-
5, madam. That the prosecution version has not been established. Those are established by the exhibits. In case of the postmortem report, if your lordship takes, how the death has occurred.
First off, he also submits that in the absence of exhibiting documents, such as post-mortem report, etc., it cannot be said that the deceased had died due to the injuries sustained by him. Which had been discovered at the time of the
Inquest and postmortem.
at the time of his post-mortem examination report. At the time of his post-examination,
Because those
post-mortem
have to be
exam.
corroborated by the witnesses. Yes, we have
Postmortem.
seen him being beaten up.
In this regard, he has relied upon the judgment of the Supreme Court in the case of Shivnath Prasad versus State of Bihar, reported in 2008 1 SCC, no, 15 SCC, 2008 15 SCC 735. Then one thing with additional PP also, right? The additional PP submit that the doctor who had done the postmortem examination of the deceased had been examined, and he had proved that the deceased had died due to the injuries sustained by him at the relevant point of time. That's next para.
Lordship, may I take leave of this honorable court, my lord? I'll just come. to my-
Okay.
Lordship,
Will-
for the
will
age
this-
of justice, my lord, may I pray matter may be sent back
No, we say, we might, but let
Might.
us be
Lo-
clear on the
Lordship,
law.
clear on the
first.
law.
Let us, in future, supposing we
My
have a
lord.
similar matter,
Lordship,
that at least we know what to do.
Right.
I mean, some citations, something.
my
if
lord,
we
I
can-
try to. Other day I've given one,
We
I
list it day
remember.
after tomorrow. Tomorrow,
Day
tomorrow,
after
okay.
tomorrow, Lordship.
Tomorrow, what is there? He'll be on.
In most of the cases, we see
Where a few documents are not.
few
exhibited. Now
documents,
there are none
but
of the
here
documents
not even a single document. in this case.
So let us have, let us write something which seems quite intelligent.
I already
Huh?
I already have. understood.
No, because you see, there is one aspect which the council here said that non-exhibiting documents, could be considered to be withholding documents also. You
It's
know,
not proved at all.
yes, and because that document could have gone against that witness also. There could be a presumption that it could have gone against. So we don't know. So, I mean, that is one aspect of the matter. But let us see, let us be enlightened a little bit more.
Lordship.
This is better tomorrow. Don't say anything. Just say, heard, so, this is better tomorrow.
Format that is given to the lower courts,
Okay.
format of 164. And in that format, that question is there that you will not be sent back to the police custody.
If you do not follow this.
I
If you do
assure
not-
you, Lordship can see the format. I've taken out the print to one, I think, yes. And the first page is illegible, but the second page is, okay, Iman, অকমানি format.
Only one page.
Oh, only one, no, there are few pages.
No, we've got two pages, yes.
Haha.
We-
The last page, Lordship will see the, before the certificate. The questions that are engrafted there. I assure you, Lordship will get this,
Yeah,
that you will not be sent back to police custody.
yeah.
That
This was
of
not-
course is there. This is not there in the present case. And I can find out cases where, of course, the one that he has found out, Justice Shiar Sharma's judgment. I couldn't find out judgments that simply not questioning or not stating to them that they will not be sent to the police custody. That will be fatal. That will question the voluntariness. I couldn't get such decision. Of course, the decisions are like, High Court has made rules for compliance of the guidelines, and those has to be followed. And here, of course, the format show that that needs to be there. But all said and done, this is Jatin Dawari is 164. Jatin Dawari is 164 is that only I had shown the way,
That only.
shown the way.
Now, what was the reason for Joya Chutia's acquittal?
No evidence. This is what is written.
What is the reason for
Joya Chuti, yes.
Joya Chutia?
No specific. No specific findings on that.
No specific finding, only page 499 of volume 2.
Oh, volume two,
Give us that 499 volume.
That is the judgment.
volume two is a color than.
Is one volume in my room. Please give it to my table.
Volume two.
499. Just findings, Julia. So there's nothing specific.
One for my
No,
table.
specific is not there.
Volume two.
My lord, there's no specific thing. Only thing is there's written findings. Having considered the evidence in entirety, I found the prosecution has been able to prove the charges against these persons. Why not against the other persons? That's not there.
No reason given.
No reason given.
No, Joya Chutia's name I don't find.
No, but Joya Chutia was made an accused.
She was made an accused. There were other accused also, but there's no reason why they were not acquitted.
And she was the one who had mentioned that Leela Khan's name. I think.
Yes,
Correct.
yes. She told it to
He told it to that
PW16.
PW 17, I think.
Huh. Joy Chandra Chutia. Joy Chutia is respond number 12. Joy Chutia, what was it? Joy Chutia,
Namine.
no. She was otherwise an accused.
You see, out here, page 40, PW 17,
Huh.
PW 17,
PW17.
in volume 1, page 40.
Yes, ma'am.
Yes.
She's the wife of Judge.
I know accused Jiten Chutia,
Hmm.
accused Joya Chutia, and accused Apsara Barwa.
Hmm.
So she says that. Then she says,
In her 164, she said
in a 164, she had said this.
yes, that Joya Chutia told me that Leela Khan has planned.
Yes.
But there's nothing why Joya Chutia was acquitted. There's nothing.
Now,
And-
Joya Chutia's name finds place in the list of accused,
Yes.
page number 441 in the
Correct,
judgment.
but then she's never, she's been charge sheeted.
Hmm.
Charges also framed against her.
Huh.
But she has been acquitted.
Acquitted, I mean, her
Acquitted.
name, I don't get it
If your
here.
lordship comes to 499, it will be very important, very
Acha,
apparent.
acha.
499.
In
Volume
case of
2.
orders.
The order is later on. Order is there. 499.
Yes, 499.
Page, paragraph 132.
Yes.
I have carefully examined the prosecution as well as defense case. I have also looked into the evidence, including cross of part of PW. I find prosecution evidence regarding involvement of these people
Hmm.
who are members, cadres, active supporters of Ben Alpha, so and so. Only this.
Hmm.
Only these people are named. And if you come to the findings next, charges are proved only against these people.
Now, what has the court said about Joya Chutia?
No, not there. That is what we can.
Was charges framed against her?
Yes, yes.
Yes,
But then she has been acquitted.
she
If
was
your- if your
the-
lordship
in the
comes to
list of-
paragraph 135, page 500.
Yes.
135. I find prosecution has failed to prove all the charges against accused
Joya Chutia.
Joya Chutia. That's it. Beyond all reasonable doubt. That's it.
No specific
No
reason why.
Lordship will go to paragraph 127. Something is written about Joya Chutia. It is seen that Tilottama Kumar, Lordship got it, 127.
PW7.
Yes.
Stated that Joya Chutia stated that Alpha took shelter in their house, Leela Khan. But PW17 has not made such statement in her evidence on oath during trial. The IO also stated that Joya Chutia gave shelter to Alpha members, but it was in the nature of hearsay evidence. And as such, I find it difficult to act on the evidence of PW17 with respect to involvement of Joya Chutia. This is the finding. So far as accused so-and-so, they were found to be involved.
Para 1.
27.
27, page 497.
And then who is this Jiten Chutia?
Jiten Chutia is witness, finally, Jiten Chutia. No, Jiten Chutia is an accused person. Jiten Chutia is accused. Accused number 13.
Yes, accused number 13.
Jiten Chutia is accused. Now, what are the allegation against him?
In the same paragraph 127, it is said.
You see, come to the evidence of PW 36.
PW Lordship.
PW 36.
Page 60.
Page 62. I do not know the accused present in the dock except accused Jiten Chutia. Now, who is the Jiten Chutia?
Is an accused, but my lord, that same paragraph of the judgment 127, where Joya Chutia's, it was said that there's no involvement. Just after Joya Chutia, it is stated page 497. Just after Jaya Chutia, so far as accused persons Mohan Chutia, Gobind Kolita, Apsara Borua, Jiten Chutia and Meena Borua are concerned, the IO only stated that they were found to be involved and they were arrested. There nothing on record as to how they were involved. Coming to the next paragraph, paragraph 128. This point actually we have missed it. It appears that prosecution has also obtained sanction from district magistrate and the Home Department to prosecute accused under section 3(4) of Explosive Substance Act and under section 10 and 13 of UAP Act. My lord, what has happened? This explosive substance prosecution sanction has been exhibited, but not by the district magistrate. The IO who has submitted the charge sheet, he has said exhibit 64 is the prosecution sanction under explosive substance. So that signature is not proved. The sanction order, that is exhibit 64, it does not say anything. It just narrates these persons are charge sheeted under this person are charge sheeted under
Exhibited by IO.
IO. The district magistrate is not brought. And interestingly, my lord,
So what happens if it is not exhibited?
that's why I'd like to point out the conviction was under 3 and 4 of Explosive Substance Act. The sanction should be given under section 7 of the Explosive Substance Act. The act ends at section 7. Now the prosecution sanction that is at page 691 of the paper book, that is volume 3, it names all the accused persons. It's a one-page document. It names all the accused persons. And thereafter it says, now being satisfied on record, I am of the opinion that there are sufficient grounds to prosecute the above mentioned persons. Hence, in exercise of powers conferred upon me under section 3 and 4. Power,
That does not change anything.
that is one point. No, my lord, why I'm saying that? Why I'm saying that? Granting of sanction is a sacrosanct act. You have to come.
No,
to
you're mentioning a wrong provision of law.
No, I'm not on that. I'm not on that, my lord. I'm not on wrong provision of law. Yes, that can be rectified. That is,
Yes.
I'm not on that. What I'm stating, granting of sanction is a sacrosanct act.
Yes.
When the granted sanctioning authority, he has to say that these materials, after going through these materials, I think it's a fit case for granting prosecution sanction. If your lordship takes up that document, that sanction, nothing is there. What I'm saying is the application of mind. If your lordship takes up the document, it just names all the accused persons. They are charged under this section in this police station case number. And now I'm according sanction.
No,
For
there was the first line in the order, Lordship will see perused a report submitted by the SP. So there was a detailed report. He has gone through.
But that is not there.
He has gone through.
He has
Now
not been
being,
examined.
and the last paragraph, now being satisfied on record. I am of the opinion. It's not it's not,
Reason, there's no
There-
reasons. The order should be speaking. There's no reasons. That is one. Secondly, my lord, this is under the Explosive Substance Act. The second act is unlawful activities, UAPA. That sanction order has not even been exhibited. The sanction under UAPA, which is under section 45 of UAPA Act, that order has not been exhibited. No one has, even no one has said that there's a sanction order. Your lordship takes up section 45 of that act.
of the UAP.
UAP.
Yes.
Section 45 says cognizance of offences. No court shall take cognizance of any offence. Number 1, under chapter 3, without the previous sanction of the central government or any officer authorized by the central government in this behalf. Now we are convicted under 10 and 13. That is chapter 3. Sections 10 and 13 fall under chapter 3. So either it has to come from the central government or some officer deputed by the central government in the state. That sanction, that
Convicted under section?
10 and 13. Those fall under chapter 3 of the act. So the sanction has to come from central government or somebody authorized by central government. That sanction is not exhibited. That is not even proved.
But have you countered that, confronted the witness?
Well, why should we, on a point of law, why should I confront the IO? or
But then
anybody?
you have admitted, but they would have said that sanction, if they say that sanction has been given.
They have to produce it. They have to exhibit it. Has to, my lord. Then why they have exhibited the Explosive Substance Act? Because when you
Unless,
exhibit it,
if you do not confirm, if you accept what they
That's
say,
what
then
my
what's the
lord-
question?
what I'm saying, when a document is exhibited by the person who has authored it or by the IO, I get an opportunity, when it is exhibited, I get an opportunity to rebut that.
Show
To
me the
pass the-
law. Show me the
because
law that it
That
is
is what
not exhibited.
cross-examination is.
You see, if they say that there is a prosecution sanction for against these persons under section so for taking up cases against them, and you don't confront it and you accept that, then where's the need for that? How does it prejudice you if they do not produce the document?
That's what, my lord, I'm saying. What I'm saying, if your lordship goes to the judgment says Explosive Substance Act prosecution sanction and UAPA sanction has been given. Now, Explosive Substance Act sanction, that is Exhibit 64, that has been produced, that has been put, that has been exhibited. I have cross-examined, that's done. Document which is not yet produced, why should I go and fill up the lacuna of the prosecution? It is their case, they have to show. Granting of
There is
sanction
no
is,
question of filling up. There's a question of you denying that such a document exists.
I am denying it. I am denying, what? I am denying
Where is your suggestion to the witness? Let us see your
My
evidence.
lord, my thing is, cross-examination is not the only way of discrediting a witness. There are citations to that. If the facts
Sure,
and circumstances,
Show us the citation.
yes, my lord, just if I may use. the-
Lordship will go,
it's there,
in fact,
there.
paragraph 128, it says that sanction was obtained even under 13 and 10 of the UAP Act.
Where is it, my lord? That is why,
But
if it is said that postmortem is done, the person has been killed by gunshot and the postmortem report is not brought, then how do we know he has been killed
in
by
certain
gunshot?
cases, I found prosecution sanction not exhibited is taken as a fatal. It will not be considered. That is there. But here is a case where your lordship will see that they have obtained, lordship will see paragraph 128, a prosecution has also obtained sanction from district magistrate and home department to prosecute accused under 3-4 of explosive and under say 10 and 13 of UAP.
Exactly, that is where, my lord.
In
3-4 is
fact-
before your lordship. Where is that document? UAPA, where is that document? That is what I'm arguing.
But in the facts of this case where, lordship, I'll just see the order of.
My lord, the
This is-
citation is,
Just a minute.
my lord, the citation I have given 1980 supplementary, 1 SCC 417,
1980.
supplementary 1, SCC 417. Now it can be paragraph 4, I guess. Paragraphs may differ. KM, no. URC. And paragraph 5, does it start with accused examine 3 defense witnesses? Paragraph 5.
Yes.
My lord, 4-5 lines after that, there's a word, cross-examination is not the only method of discrediting a witness.
Yeah.
If the oral testimony of certain witnesses is contrary to proved facts, their evidence might well be discarded on the ground.
Yeah.
This part, if their testimony is on the face of it unacceptable, courts are not bound to accept their testimony merely because there was no cross-examination. Now, my lord, in IO, there were two IOs, one who has conducted the investigation, one who has given the charge sheet. Neither of the IOs say that there has been sanction, there is a prosecution sanction under UAPA. Why should I cross-examine? Neither of that. Yes, the second IO, he has exhibited the explosive substance thing. He has exhibited that, but nobody has said about UAPA.
Let us see what they have said.
In the charge sheet, they have said two prosecution sanction.
No,
orders.
charge sheet, no, let us see the evidence,
I
whether they have
also,
said the prosecution sanction is there or not.
My lord takes up volume 1. Page 108 is the IO, volume 1, page 108. This is the main investigating IO. 110, if your lordship takes up, just before cross-examination, he has exhibited certain seizure lists and 164 statements of certain people. His examination ends there. Exhibiting of his documents ends there.
Yes,
Then-
yes, sir.
Very poor behind that.
Puravaha? Knowledge. And he's a accused.
IO has not exhibited the sanction.
Lordship will see at page 111,
Yes, my lord. Yeah,
last lines,
I'll come to that, my lord, if I
Ah.
may. Last line, my lord.
last but 4-5 lines.
They have exhibited the prosecution sanction of explosive act, but mentioned UAPA. If your lordship sees. I handed over the case diary to my successor, Lolit Buragohain. He has not been examined. Thereafter, Lalit Buragohai collected prosecution sanction and filed charge sheet against accused persons mentioned above under so and so, read with section 3(4) of ES Act and read with section 10(13) of UAP Act. Exhibit 64 copy of prosecution sanction. Now this exhibit 64 is the prosecution sanction of under ES Act.
Where page?
My lord, page
111.
page 691 of volume 3.
These statements are at 111.
In fact, he has stated in that saying that in exercise of powers conferred under me of ES Act, I do hereby grant sanction. So it states about only Explosive Substance Act. Page 691. Last paragraph, my lord. Now being satisfied on the record, I am of the opinion that there are sufficient grounds to prosecute the above mentioned persons, and hence I so and so in exercise of powers conferred under me under section 3 and 4, this should be 7. ES Act do hereby grant prosecution section. So this is, if at all a sanction, it is under the Explosive Substance Act. Where is the sanction under UAPA? And it has to come from the central government. This is a district magistrate.
Lordship will see the charge sheet. Charge sheet, the police have stated I have collected 2 sanction orders.
But it's not there. Is it there?
Charge sheet, it is there. I have collected 2 sanction orders. Lordship will see at page 600 and 700 perhaps. It's 710, paper book 3, 710. 2 prosecution sanction orders.
But where is it, my lord? I have been denied the privilege of cross-examining by not exhibiting that. There comes 114G, that may not have been a proper sanction. I do not know the contents. You have withheld the document.
Those things they have not brought in the cross.
Not required, my lord. Facts and law I need not bring on cross. That's why I said cross is not the only way of discrediting a witness.
Lordship got it 710, last but 4 lines. 2 prosecution sanction orders.
2 prosecution sanction orders, okay, but under what provision?
Yes, those things are not there, but nothing was brought in cross.
So
And plus, the
but-
police officer had said that after getting prosecution sanction, we have filed charge sheet under
But
both.
he
the
has not specifically stated that prosecution sanction and for
UAP.
Yes,
for the USP Act of being granted or given, or he has it.
in one of the judgments that I'm supposed to bring it tomorrow, their prosecution
Tomorrow?
sanction, tomorrow in that another
Ah,
case. Their prosecution sanction order was not exhibited and it was considered fatal in the facts and circumstances of that case.
In fact, my lord, this Lalit Buragohai, who had collected the prosecution sanctions and filed charge sheet, the police person, he has not been examined. Lalit, the statement thereafter, Lalit Buragohai collected prosecution sanction and filed charge sheet against the accused persons as mentioned above so and so.
That is in page.
Page 111 of volume 1. My lord, sanction, if it is not exhibited, how do we know which authority has given, whether that person is in fact a central government person or deputed by central government? Lordship comes with 111. Thereafter, Lalit Buragohai collected prosecution sanction is not examined. Last but 5 lines. He is not examined.
He is not added as a witness in the charge sheet also.
He has collected the prosecution sanction, if at all you have collected. So the presumption that there is no sanction is apparent.
Let us get. Okay, whatever. Okay, that I will get extra chocolates. Now, okay, with regard to some judgments, you were supposed to give whether section 164 statements can be made the basis for conviction.
Oh, 164
Can be,
can
can
become
be.
the
Even retracted confessions can
retracted,
be,
yes.
But that cannot be the sole basis of conviction.
cannot be the sole.
No, sole basis, there is one Pabunni case that I had placed once. Pabunni case, it is said, only sole basis of confession, one can be convicted. If it is, of course, retracted, then some corroboration
In
perhaps.
fact, I have given my lord judge, my compilation of judgments, there's serial number 8. 2004, 7 SCC.
Just a minute, I'll have to look, where is the compilation? Now, there also, see the compilation there. You'll have taken it back, we don't. Huh? Bottom. Okay, those,
My synopsis will also be there. I think Pabunni case I'm referring.
If your lordship takes up that compilation,
uh,
page 115 of that compilation.
yes,
Well, paragraph 18 says about the voluntariness of the confession.
yeah,
10, my lord, next page, para 20, page 116.
yeah.
In Pyarelal, the same principle in regard to the evidentiary value of retracted confessions has been reiterated. A retracted confession may form the legal basis of a conviction if the court is satisfied that it was true and voluntarily made. But it has been held that a court shall not base a conviction on such confession without corroboration. It is not a rule of law, but is only a rule of prudence.
So-
No, my lord,
so
no, my
it
lord, later on. It cannot even be laid down as the inflexible rule of prudence that under no circumstances such a conviction can be made without corroboration. For a court may in a particular case be convinced of the absolute truth of a conviction and prepared to act upon it without corroboration. But it may be laid down as a general rule of practice that it is unsafe to rely upon a confession, much less on a retracted confession, unless the court is satisfied that the retracted confession is true, voluntarily made, and been corroborated material particulars. Here comes the concept voluntarily made. That's why I was relying that it was specifically stated, not stated, that I will not send you back to the police. And that's what our High Court judgment says, that I had given separately, that if you do not put that question, he's always under the fear that I will be sent to police. So that confession is not.
Which one, what was that case?
My lord, I gave it separately. 2004 GLT, I guess. It's a small. Copy it, asking this. I had given a copy, my lord.
Yeah, probably you have given, we're not saying that you have not given, the problem is that this is
It's 2022, 2022, 4 GLT,
2022 for GLT
679.
679.
My lord, there it will be paragraph 32 and 33. But if I may say what 32 states.
Yes.
Carefully perusing the said caution recorded in the form of recording confession statement, we find that the appellant was not sufficiently assured that in the event of refusal to make the confession statement, he would not be given to police custody again. Therefore, in our considered opinion, appellant did not get assurance from the court that he was free to confess his guilt, if any, voluntarily without having any fear of going back to police custody. So this question was also not put in this case.
So in our case, this question was not in the form.
No, not in the form.
Not in the form, but there is a form made for recording of confession statement.
Yes, madam.
Made by whom? By the,
Under Supreme Court guidelines that has been made.
This is by the High Court,
what I call.
Guwahati High Court.
So this one contains that particular question.
Hmm.
It is not there in the form
In our-
used by the
Yes.
trial court. By the concerned magistrate.
So under that circumstances, it's not voluntary. That's what this court has said in that judgment. So if it's not voluntary, whether it is retracted or unretracted, there's no confession.
Besides the confession being exculpatory.
Exculpatory, and what does it say? It does not say of planting of bomb. This is a bomb blast. It does not say, I just showed the way to the
Field.
field. That's it. 10 days before the incident and the day on which it is supposed to have been done, from that very day, the field is under police custody. As per the message, because Independence Day was coming.
Anything else?
As far as, of course, that question, Lordship will just go to the confession again. Confession, it is of course in the way the format is. Do you know that a confession may be used against you? Yes, I know that. Being tutored, I want to make with your confession be true. The page number 666 of volume 3. Here.
Yeah.
From the very first page, if we see, building the satisfied vis-a-vis reflection time, then.
No, he says that I want to make confession on my own volition.
Yes, this is what, in presence of that, simply saying that, of course, I'm not backed with any decision, but having said this, yes, whatever I shall speak the truth only. In presence of this statement, simply that he was not assured that he'll not be sent back will not be fatal in my humble submission.
My lord, the
Because
same
that
page.
question is only to see the voluntariness.
Exactly, madam. Same page.
This is,
Point C, same page. It must be clearly understood that the questioning of an accused in order to discover if the making of a confession is voluntary is not a mere formality. Magistrate must apply his mind judicially and endeavor to base his finding upon the definite premises and grounds.
yes, there is no quarrel with that proposition, that is there, but there are few questions even before that, so and so, everything is there. You are not bound, he was explained. Those, everything was followed. And he, I mean, in clear words, he said, I shall speak the truth only. So in view of this, and in fact.
But what about this judgment of this court, which says that carefully perusing the said caution recorded in the form of recording confessional statement, we find that the appellant was not sufficiently assured that in the refusal to make confessional statement, he would not be given to the police custody again.
Yes, of course, that is
Madam,
there,
next paragraph,
that is there.
next paragraph.
But in the facts of this case, and in certain acts, TADA Act, in fact, it is a very mandatory provision that he should be stated, he should be said. Here it's a guideline, here it's a format.
No, but then when this court has already held
And the next
that
paragraph is more
when
important.
such an assurance is not given. then
Paragraph
it
33,
cannot be
madam.
said that it was voluntarily given. Can we hold otherwise? And if we have to hold otherwise, then we'll have to send it to the larger bench.
No, not holding it otherwise, but in the facts of that case, it is said. If your lordship can gauge the voluntariness in the facts of a particular case, it
Your
can be
lordship takes up-
perhaps differentiated.
I would say lordship takes up paragraph 30 of that judgment. The questions that have been asked are there. Paragraph 30. First question, I am not a police officer, but a magistrate. 2, you are not bound to confess the guilt. 3, during the course of your confession statement made by you, 4, you shall not make the confession as per version of others. 5, you shall not tell a lie. 6, you confess your guilt. Same questions, my lord. These were rather direct. In this one, it's a more sober manner of asking. Then what does paragraph 33 says? In the
No,
absence of,
slightly different. Out here it was said that are you making confession on being tutored by somebody?
yes, my lord, the second, you shall not make any, question number 4, you shall not make any confession as per the version of others. This was more direct, these questions. In our case, it's a more sober way of us telling the same things. Then paragraph 33. In the absence of any assurance in this regard, it cannot be concluded that the appellant was free from fear of being sent to custody of police. In our considered opinion, the said evidence and the manner in which the confession recorded do not inspire confidence to believe that the said confession statement was free and voluntary. What more is there, my lord? Squarely covers.
If this particular thing, will your confession be true, and his answer to this? If it is there in that particular case, in spite of that, this was not, then the case can be said to be same.
And in his
If in
330
that particular case that he has placed, if in that case, this question and answer was there, and in spite of this presence of this question and answer, that was considered as fatal, then it can be same. But this question, will your confession be true in whatever I'll speak the truth, that perhaps was not there in that particular judgment.
No, in this judgment that he has given,
Huh,
the question that he would not be sent back to police
huh,
custody.
it was there.
It was not there.
It was not there. And it was-
Similarly, here also it is not.
It is similarly here also not there. But the presence of the question in our instant case, question number 5, that are you speaking the truth? Yes, I shall speak the truth. This particular question and answer was perhaps not there in that judgment.
No, you shall not tell a lie.
You shall not have a right.
Yes, here, will your confession be true? Yes, I shall speak. I shall speak the truth only. And the answer, you shall not tell a lie.
You shall not, I know.
I know. This was little
Or it's just saying
gauging
half
voluntariness.
empty
would
glass
be-
is also half filled. It's two way of looking into the same
Gauging
thing.
voluntariness would be difficult, I know. But here, Lordship will see in so many words, whatever I shall speak the truth. Here, I know will not suffice. So in the facts of that case, it can be differentiated.
Going by that, my lord, in that case, it was not retracted. But in this present case, question number 44, that was put to the confessed person who has confessed in his 313 statement. His answer was, police forced me to make confession before magistrate. I made confession due to fear of police atrocity. I did not make the confession voluntarily. I am not involved in the commission alleged offense. Police threatened me with dire consequences if I did not confess as taught by police. This has to be taken.
And moreover, I'm not saying that on this confession, conviction of Jatin Dawari can be awarded, can be. What I am on is confession is a link in the chain of circumstances. Because confession here, the inculpatory part is not there. He has not planted the bomb and all. So it is a link in the chain.
But what is the chain? What is the chain?
Chain that I have just narrated. I hope my written submission is there with your lordship in the record.
I don't know.
Her lordship, I have given it separately next day.
Okay, yes, I remember you gave a 2-page,
2-3 pages only.
2 pages.
Citing all those 164 statements, which they
No,
did not.
only chain.
Anyway.
I'll again give it if it is not there
No.
in the record.
My lord, to sum up,
I'll give it.
I cannot be convicted under UAPA. There's no sanction. So if this UAPA goes, it has to be specifically said 3022 come that I have done it. Where is the evidence of that? As for my client Muhi Hendik, it is said that my car was used. No witness had come to say this car was roaming around in that area, locality, before the day of incident. IO says that when he arrested me with a pocket book, pocket diary. In cross-examination, say I do not know the contents of the pocket diary.
Anyway,
Only link is I used to call up one lady.
I think that Jiten Chutia might be the person with the motorbike.
Joya Chutia.
Jiten Chutia,
Jiten-
motorbike. I have not placed reliance on that motorbike thing. Jiten Chutia is one of the accused. Perhaps he was.
I
with
just
the-
wanted to know what was his motorbike.
Jiten Chutia. He is acquitted. 14, accused number 14.
30.
36,
George
PW 36 had mentioned him.
Bike.
এই bike এখন যে আছিলে যে হেৰি পালচাৰ না কিবা এখন of course that is not related to have not taken.
Anyway, I think we're more or less going to.
The chain of circumstances, I'll just give lordship can then jot it down in the judgment.
It'll be somewhere.
No, lost per I can give it to
No,
him.
no, it'll be somewhere,
Acha, acha.
I think. It's going to become very voluminous otherwise for us.
Hmm.
Supreme Court will have a tough time going through that. But
My
it's
lord,
very short.
Other bomb blast case of NDFB, it was a paper book of 15 volumes.
My God.
That is before Supreme Court now.
Yeah, we do not know how to write such long letters. Our mental capacity is like.
That was 650 witnesses
My
and
God.
680 something exhibits.
Long judgments are difficult. Indra Sawhney case. I keep on reading. Lastly, we get I get something to judge. But long judgments are very difficult to comprehend and.
Keshavanda Bharati, if I start, I forget what I was reading. After page 200, what was page
Keshavananda,
200?
What was
Indra
the issue?
Sawhney,
Exactly.
these are very difficult. Judgment should be short, like Privy Council,
Yes.
Federal Court. I like those judgments, very short.
Anyway, okay, right. The learned counsel for the, Acha, one thing, what is the difference between the statements made under the Customs Act and the CRPC?
Customs Act.
108. Those are admissible as evidence,
That is admissible.
Hmm.
That is
but I
admissible.
think 164, it's only, it has to be corroborated.
In fact, that was-
164, that is prudence requires.
Prudence requires.
Prudence requires some corroboration if it is retracted.
and if made voluntary.
And if it is not retracted, it can be so.
Yes,
properly.
can
In
be
fact,
sole
custom
basis.
is same with our earlier TADA Act. If you make a statement before the police, that section 67 or 68 of TADA.
Okay, right. I'm just recording, so just wherever I go wrong, just correct me. The learned counsel for the appellant submits that prosecution sanction under section
10 and 13.
10 and 13.
65 of.
No, 10 and 13
Ah.
of the UAPA Act, UAP Act had not been exhibited before the learned trial court, thereby implying that no sanction for the same had been given. He also submits that while prosecution sanction under section 7 of the Explosive Substances Act
3 and 4. Like you said.
had been given for prosecuting the appellants under section 3 and 4 of the Explosive Substances Act, the same had been exhibited by the IO and not by the
District magistrate
district magistrate who
Right.
had
granted.
drafted the said sanction order. He also submits that though the sanction order for prosecution under the Explosive Substances Act had been apparently made under section 4,
7. It should be under 7,
had been made under section
3 and 4.
3 and 4, the same can be read as an order made under section 7 of the ES Act. Correct? That, so I don't think no one has got any problem with that. Okay. Next para. The learned counsel for the appellant further submits that in terms of the evidence given by PW
57.
57. That to the, which is to the effect that no, what 57 says what?
The second IO who has executed.
Which is to the effect that he handed over the case diary to his successor,
Lalit Burago.
Lalit Buragohain, who thereafter collected the prosecution sanction under the under the Explosive Substances Act. Actually, it says read with
Read with, but
Read-
cannot be read with.
and read with section 10/13 of the UAP Act, there cannot be one prosecution sanction for both the acts. Full stop. He submits that while prosecution sanction under Explosive Substances Act would have to be given by
District magistrate.
the district magistrate, the prosecution sanction made under which section? 45.
45 of
Or
UAP,
section 45 of the UAP Act would have to be given by the
Central government
central government. Full stop.
or any person authorized by central government.
Or any other person authorized by the central government. Full stop. In this case, there is nothing to show as to who had issued the. No, there's nothing to show as to whether any prosecution sanction had been issued and by whom it had been issued
Under UAP.
under the UAP Act. Next para. One of the questions that has to be considered is whether the retracted confessional statement of Jatin Dwari could have been made the basis for convicting Jatin Dwari and the other appellants. Full stop. In this respect, the learned additional PP has taken us to the confessional statement form under section 164 CRPC, which had been used by the magistrate for recording the confessional statement, for recording the statement,
For recording the confession statement.
Confessions.
for recording the confessional statement
164 only.
of Jatin Dwari. She has taken us to question number 4 in the set form, which is to the following effect. Are you making confession on being tutored by somebody? The answer to the above was as follows. Inverted commas, no, I want to make confession on my own volition. First, the learned additional PP submits that the above answer given by by Jatin Dwari clearly showed that the confession had been made voluntarily. She submits that the next para, the learned additional PP submits, though in the form for recording confessional statement under section 164 CRPC made by the Guwahati High Court and which has to be used uniformly throughout the jurisdiction of the Guwahati High Court, there is a question which which requires that the person who is to make the statement is to be informed that he would not be sent back to police custody if he did not confess, even if he did not confess, comma, the said question in the form to be used, the said question in the form made by the Guwahati High Court is not a part of the questions enumerated in the confessional statement form used by the judicial magistrate, comma, who recorded the confession of Jatin Dwari. Full stop. The question that is a part of the form for recording confessional statement under section 164 CRPC made by the Guwahati High Court is as follows. Question number 7, actually, question number 7, Roman 7 is as follows. Invert commas, I assure you that you will not be remanded / sent back to police custody if you do not confess. SEND, not P, it's a D. Full stop. Are you clear about it? Question mark. Then below ANS dot dot. That's all. Invert commas close. Full stop. The next para, the counsel for the appellant submits that the absence of the said question in the form used by the magistrate recording the confession statement of Jatin Dwari and the fact that Jatin Dwari had not made any statement which would have any semblance to answering the above question, comma, prior to recording his confessional statement. What have I said? How did it start? The question? Would have to be considered, would have to be the, would only imply that the confessional statement made by Jatin Dwari was not voluntary, was not freely voluntary, comma, as held by the division bench of this court in the case of Abdul Subhan, SUBHAN versus State of Assam, reported in 2022, 4 GLT 679. That's all. Anything else? Have we missed out anything else? Yes,
You can write my submissions as far as the prosecution sanction is concerned and all.
okay, just right. Just right.
As far as Explosive Substance Act, there is a sanction order.
That he's not disputing that.
And sanction only to point that
Acha, one more thing, you just right. The learned counsel for the appellant submits that as there is no prosecution sanction exhibited in respect of the UNP Act, comma, no conviction of the appellant the appellants could have been made in respect of the UAP Act. Full stop. That being the case, comma, the prosecution required some evidence to be led showing the involvement of the appellants in the bomb blast that had occurred. full stop. However, there being no such evidence in that, on that issue, comma, the appellants would have to be acquitted of the charges leveled against, framed against them. Full stop. Next. Then you write, Miss L. Jahan, learned additional PP, submits that.
As far as ES Act is concerned, there is a sanction given by the district magistrate, exhibited by the police. There is no bar in exhibiting that document by police, that only district magistrate has to do it. What his contention is that district magistrate didn't exhibit it, he was not examined. Now, my contention is that this has been exhibited by the police. It's not mandatory that district magistrate has to come and exhibit it. So as far as ES is concerned, there is prosecution sanction which is there on record. Under the UAP, Lordship has seen the police have stated that I have collected the sanction orders. Charge sheet showed that there were 2 sanction orders that they had collected and they had filed the charge sheet.
No,
So in these facts,
it says read with, that is the problem.
in the charge sheet, it is written 2 sanction orders they have collected. So in view of that, non-exhibiting of the sanction order may not be
Submits
fitted.
submits that. There is no infirmity in the prosecution, in the exhibition of the, in the district magistrate not exhibiting the prosecution sanction made under the Explosive Substance Act, as the same has been exhibited by the IO,
Aye.
comma, to whom the prosecution sanction had been given. Full stop.
As far as UAP, it
The
is,
charge
there were
sheet is
2.
not an exhibit, charge sheet, contents of a charge sheet is not evidence. There are
Yeah, that
sanctions.
is there. In the facts of the case, I'm saying that in the charge sheet. it's written.
With regard to the UAP Act, what is your
In regard to the UAP Act, it is mentioned in the charge sheet that there were 2 prosecution sanctions.
stop, in respect of the prosecutions, in respect of the non-exhibition of the, in respect of non-exhibiting the prosecution sanction under the UAP Act, comma, the learned additional PP submits that the charge sheet having categorically stated that 2 prosecution sanctions had been made, comma, the non-exhibiting the prosecution sanction under the UAP Act cannot be fatal to the prosecution case.
In the facts of the cases.
That's all.
And
And
know that the confession is voluntariness was checked and he had specifically stated that it is true. So assuring that he'll not be sent will not be again fatal.
okay, you just said that. And the next para, the additional PP submits that the voluntariness of the appellants and of Jatin Deori's confession having been proved by his own statement that it was made on his own volition, comma, the absence of giving any reassurance to the appellant, to Jatin Deori, that he would not be sent back to police custody if he did not make any confession, was redundant. That's all.
My lord, just one more. This charge sheet, who the police officer who has submitted, Lalit Buragohai, he has not been made a.
Okay,
witness.
just said one more thing. The
So that statement. of
appellant's
two
counsel
prosecution
also
sanctions
submits
was
that the
Officer,
police officer Lalit Buragohai,
Lalit Buragohai,
comma, who had made the charge sheet,
who had submitted the charge sheet.
who had submitted the charge sheet, was not examined as a prosecution witness by the in the trial, in the learned trial court.
This is one
Now-
step.
Huh?
This is only one step for your lordship.
Now the problem will come on us. Okay. Heard so, huh? You got the names? I don't know. Heard Mr. A.K. Das. A.K. Das for the appellant in criminal appeal 311/2019. Mr. D.K. Bhattacharya for the appellant in criminal appeal number 305/19. Mr. A. Kanikar for the appellant. 365. 365. Where is in your case, how many persons?
My case,
Yeah.
1%. Moving ahead.
And in your case,
No, three. no.
that is Mr.
Dipali,
Dipanjali.
Three,
Lisa and Jackie.
what is your number?
311.
The appellants. No. And so also heard Mrs. Jahan, learned additional PP. Hearing concluded, judgment reserved. So either it will, the judgment will be passed and everything will be quiet, or we are going to be
Yes.
well known.
Nothing will happen.
Including me.
It will be quiet.
Absolutely.
Absolutely quiet.
Anyway, so we are finished. Now our part comes.
Yes. sir. I think I'll give my written submission because it must have been lost in between so many papers.
I doubt. It should be somewhere.
Anyway, I can give it a few pages only. I can give it tomorrow, Lord.
Acha, what is the judgment? This book, 1980?
So that cross-examination cannot be a sole basis of discrediting a witness. 1980 supplementary 1417. I guess.
Just write one thing, just write. In the case of B.S. Yadav and others, versus State of Haryana and others, 1980 supply SCC 524. Is it?
Just, my lord, I'll just check it. 417.
Acha, supply one you said, no?
Yes, supplementary 1 SCC 417.
Now, what is this? It's supplementary, not supplementary one.
But the same thing, madam.
Huh?
It will be same book. Same book.
Same book.
Same
It
417.
is supply.
So there is no volume. Only
There's no
one sub-
volume.
So page 417 it starts, my lord, if your lordship checks. The software shows as something.
No, Jawar Singh.
Yes,
well,
that,
okay.
that.
1980 supply SCC 417. The apex court has held. Tara?
5, my lord. 5.
Has held that cross-examination is not the only method of discrediting a witness. Full stop. If the oral testimony of certain witness is contrary to proved facts, their evidence might well be discarded on that ground.
Next line, madam.
If their testimony is on the face of it unacceptable, courts are not bound to accept their testimony merely because there was no cross-examination. Full stop. I just take that.
In my submission also, after prosecution witness, after that sanction thing comes, their lordship can write that there were, nothing was brought in cross-examination. Now they cannot raise. That part.
Okay, just right.
It was not
Sanction.
brought in
Law
cross-
point, my lord. Law point. Why do we have to ask the witness? How will the witness know?
That is my
With regard to what?
That prosecution
Prosecution
sanction
sanction.
was
Okay, with
not
regard to
there.
prosecution sanction, you just write, huh? And the additional PP also submits that the witnesses were not confronted with regard to non-exhibiting the prosecution sanction of the non-exhibition, prosecution sanction
Under the UFCA.
under the UAP Act. And as such ground cannot be taken at the appellate stage.
How will I, Lalit Buragohai is not before the court. How will I put the question to him, whether you have collected or not?
No, he was one of the police officer. They could have asked the other one.
Okay, anyway,
Lordship.
at last, you have finished. We have to look at-